We are joined by Kate Collier from Weber Wenzel, who has provided us with a lot of interesting information in her talk this morning here at the Saiosh conference. Thank you for joining us,
Oh,
Kate.
such a pleasure. It's always great to be here.
Thank you. Just a few questions based on your topic this morning. In terms of health and safety governance, how important is the establishment of clear and concise policies for effective risk management?
I think it's fundamental because if the policies aren't clear, we aren't able to properly enforce them. There's a lot of wiggle room for people then to try and find reasons why a policy may not apply in a particular circumstance. And if people know what they need to do, they can do it. And if we don't have a clear policy, we're behind the eight ball from the beginning.
You made a very interesting point this morning that a policy has to be substantiated and supported by evidence from a risk assessment. Can you tell us a little bit more about that?
Yeah, sure. So the policy and procedures really set out the way in which work should be done so that it can be done safely. The only way to properly identify and inform how work needs to be done safely is by assessing and identifying what those risks and risk exposures are to employees and then how to avoid them. So until we know what can go wrong, we don't know how to avoid them. So we must start with the risk assessment process.
The depth of the risk assessment was also something that you mentioned, and that simply doing a JSA or maybe considering risk in general isn't enough. How far should an employer go to identify risk and to determine and mitigate the risk that has been identified?
So the Act is quite broad in its wording. It talks about all hazards that employees may be exposed to. From a legal perspective, it would be anything that is foreseeable. But it needs to be reasonably foreseeable in understanding the way in which work may be performed or tools and machinery would be used, particularly in the environment that work is being carried out in. So it's never going to be sufficient to simply say use PPE, for example. We need to go to the outset. How is this going to be performed, and how can we completely firstly try and eliminate risk, and if we can't, by changing the way work is done, what control measures are then put in place to make it safe? So it needs to be comprehensive with reference to the entire sequence of work.
Okay. And then with regards to the application of the law itself in determining liability, in your topic this morning you discussed that the employer naturally is ultimately accountable for everything related to occupational health and safety, and that naturally if a 16.2 is appointed, that doesn't take away such accountability or liability from the said employer,
Yes.
unless certain facts are naturally provided in terms of the delineation of responsibilities by means of appointment. What is the relationship between then the 16.2 as they carry out these responsibilities that have been delegated to them by means of their appointment letter, and how can liability then be delineated in this regard should an incident have happened but the CEO isn't reachable, they may be overseas, they're only in the country maybe 2 weeks of the year.
And it happens.
It does. So what happens in cases like this?
So from an overarching perspective, it's going to firstly depend on how much authority was given to the Section 16.2, so what kind of authority and responsibilities were placed on them. But ultimately, they must act subject to the direction and control of the CEO and the board. So how was that reporting done, and what kind of tools and support was that Section 16.2 given? And then it comes down to, did they do their job? And if the CEO was happy that they were doing their job, was that a reasonable assessment of it? And most particularly, and as we heard in the cases today, if we're not happy that the job is being done, did the board and CEO take action to address it the moment the concerns first came up? And that's the key to limiting that onward liability to the board and the employer.
So if I'm understanding you correctly, a 16.2 can be held accountable.
Absolutely. If they are negligent and don't do their job, despite being competent, able, and have been provided with all the resources, they can absolutely be held liable.
The question on competency then. Who determines what level of competency a 16.2 should have? How is that determined?
Yeah, so it's going to vary depending on what they are expected to do and what duties are placed on them. You would assess competency with reference to experience, skill, qualifications for a particular role, and experience.
Okay. So just to round off and to finalize, because for me it's a really interesting question, it's something that comes up often in the classes that I teach as well, is a 16.2 can be held accountable. The grey area that I think that exists in legislation as it stands is where the law says that because the 16.2 is appointed, it doesn't mean that the 16.1 is not free from any liability or responsibility. And then the perception is created by the 16.2s that I'm okay.
Correct. So I think that the fundamental point is that the Act contemplates that any person can be held liable. That any person includes the employer broadly. They can be prosecuted and represented by ordinarily the CEO or a board member. But in addition, there are personal responsibilities placed on key legal appointee holders, the CEO, who's ultimately the policeman, and then anyone else who's been delegated with a legal appointment. And if they have been personally negligent in failing to perform their duty, they can be held liable individually as well as the company being held as a corporate entity.
Okay, and this would stand even in cases where a person is appointed as a 16.2, but they have other general duties and functions within the corporate structure as well.
Yes, correct.
So that appointment letter becomes an
Very
enforcement
important.
document.
Absolutely. It has to set out the scope, really, and what the barrier and what the boundaries are of someone's accountability, and then whether they are discharging those duties placed on them.
Okay. Very, very interesting. Thank you very much for your
Absolute pleasure.
time.
Always great to be here.
Thank you.